Hello, Paul. Great. Um, yes, I think we can already start. First of all, I want to apologize because of my little technical problem. Um, I'm receiving an error from MS Teams saying that there is no camera found on my computer, which is the first time this is happening to me. So you will just hear my voice. Um, Welcome to this online seminar, which is part of the LEADS Project online seminar series. And today we have two distinguished speakers, Professor Paul de Hert and Professor Vagelis Papakonstantinou. Today they will talk about the recently published book, their recently published book, The Regulation of Digital Technologies in the EU, Act-ification, GDPR mimesis, and the EU law brutality at play. I think most of the people who are on the call, on the meeting at this moment, are already familiar with the work of Paul and Vagelis. But I will just quickly introduce them in case there are some external participants who are not from LSTS or the LEAS project. Professor Vagelis Papakonstantinou is a professor of personal data protection law at the Faculty of Law and Criminology of the Free University of Brussels, focusing on cybersecurity, intellectual property, and the broader topic of technology regulation. He works through the Cyber and Data Security Lab, for which he is the scientific coordinator, as well as through VUB's research group on law, science, technology, and society, and the Brussels Privacy Hub. Paul de Hert is a professor at the Faculty of Law and Criminology at the VUB and an associate professor at the Tilburg Institute for Law and Technology, University of Tilburg. He is the director of VUB's research group on human rights, vice dean of the Faculty of Law and Criminology, and the former director of the LSTS and the Department of Interdisciplinary Studies of Law. I will now leave the floor to Professor Vagelis Papakonstantinou to briefly present the book, and then there will be ample time for Q&A session. Thank you.
Thanks, Ingia. Hello, everybody. Thank you for being here. I'm Vagelis. First of all, we co-authored with Paul, so we decided that I do the presentation, and then he jumps in during the question session, which also for this purpose, I'll try to keep my presentation brief in order to encourage discussion and exchanges later, which after all, I think is the purpose of the seminars anyway. Now, yeah, regarding the book, and by way of a brief introduction to that and how it came to be, first of all, because sometimes background is helpful to be aware of. But I also think because within LSTS you have been familiar with the process of the blog posts and the book because we've been circulating in the mailing list anyway. But anyway, here it is. So a couple of years ago, we started identifying what we thought were certain lawmaking phenomena in EU law as regards the regulation of digital technologies. So the first observation was an external one, Act-ification. So we wrote a blog about that, kindly accepted in the European Law blog, on specifically on Act-ification and how it came to be. Then we also thought, having reviewed the drafts back then, the draft of the various acts, the AI Act, the DGA, DMA, DSA, etc. So having reviewed them all, because please note that all came during the tenure of the outgoing commission, so since 2019 onwards. So having reviewed all these texts, we thought we identified GDPR mimesis phenomenon, and hence a second separate blog post, again in ELB, that followed a few months later. And then, perhaps bringing them, the two phenomena together, we thought we identified some brutalism. I'm not certain the word is correct, but brutality. We kept the word brutality anyway. In the way EU law was regulating digital technologies, hence the third part. Now, having three separate blog posts published in ELB was something, of course, but we thought we could work on it a bit further, and we developed them into a paper. And the paper was published in Technology Regulation Journal, bringing them three together. What was the shortcoming that was identified immediately with the paper was that the analysis was too short. So it is one thing to write a blog post where you have to make a good impression and be fast and be quick. It's one thing, you do not have to explain many things, but when you start putting things on academically on paper with the references and the time needed to absorb and discuss, then it's a different story. And bringing all three phenomena under a common roof, that was even more difficult. And already the paper that is online, luckily it's openly accessible to all. So already the paper was scratching the roof, the ceiling of an academic paper at 12 or more thousand words. I think after the reviews, the peer review process, it was 13 or even 14K words. So already at the ceiling of what is acceptable in Europe as an academic paper, and still the reviewers thought that we had more things to explain, and also the editor too, that still a bit more explanation was missing. Hence the book. We thought that we needed to close this procedure and produce a book where luckily we had all the luxury, were afforded all the luxury in the world to explain ourselves each phenomenon separately, and also attempt to bring all under a common roof that to us was evident, but maybe to you, we'll see how it goes today with the discussion, it is not. Therefore, altogether, three blog posts, all published at ALB, all still on the internet. You can, even if you have not read the book, you can read the blogs. Also an academic paper, bringing them all together, and now the book that, after Imge's kind invitation, we are here to discuss more than present. So this is the necessary background, and now, as regards the structure of the book, it follows the background. It's three separate phenomena. So actification, GDPR mimesis, EU law brutality, that at first sight are not interconnected. They're separate. You can read the chapter, the three first chapters. So if I'm looking to my left or right, depending how the screen is viewable to you, it's because I have the table of contents next to me. So there will be no presentation, no PowerPoint, so just bear with me for 15 or 20 minutes while I go over the chapters and the structure of the book. So you can read part one on actification separately and just stick with the actification phenomenon, or you can go directly to part two. They're not interconnected on the GDPR mimesis phenomenon and stick with that. Or you can choose to go to part three on the EU law brutality phenomenon and leave it at that. They're independent. They're only brought together at the last part of the last closing chapter of our book, but otherwise separate phenomena that outwardly, at least, do not affect each other. Having said that, however, an immediate first remark by the authors, okay, is that we move from the externals to the internals. So actification, and I'll go on its separate phenomenon in a minute over each one. So actification is external. It's easy, it's the act. You see the word act everywhere, TGA, DMA, AI act. So this is that, this is actification. So it's fairly external, easily observable, easy to establish, it's an act. So Act-ification, external. Then GDPR mimesis, you need to read the text because with Act you can stick to the title and that's it. It's affirmed. When it goes to GDPR mimesis, you need to read the text. And having read the text of the AI Act, for example, maybe you get the feeling that you've seen it before. It's GDPR-like, hence GDPR mimesis phenomenon, but you have to read the text. And so we move from the externals, the title, to the internals, how the text, the actual law is written and what it says. And even if we go past this internal level, we reach the core of the lawmaking, which is EU law brutality. And no longer does it refer to actual provisions or the title. It refers to the methodology, to the legal mechanism, to the mechanics, to the engineering of the lawmaking process. What has changed in the lawmaking process here in digital technologies as compared to other fields of EU law. So we move from the externals to the internals, but anyway, in seeing independent phenomena. So yeah, that was the introduction, and then please allow me to briefly go over each one of these phenomena and the way we define them. And yeah, and another disclaimer. Of course, we are lawyers. We live with disclaimers. So the first disclaimer is that the terms are not to be taken literally. So there is no brutality. Nobody accuses the EU law of being brutal. Quite the contrary is the case, because all caution has been taken for EU law not to be brutal since the inception of the EU. Back in the 50s, that was the main concern of the EU drafters, EU creators, not to be brutal towards member states. So we are not accusing it of being brutal. So please accept the terms or Act-ification. We do not mean that all new law, EU law regulating digital technologies is an act, because it plainly isn't. There are directives and and when it comes to mimesis, again, it's not mimetism, it's not to be taken literally. We use the names in a metaphorical sometimes way. So again, when it comes to Act-ification, the easiest to confirm phenomenon, you immediately notice that when it comes to the regulation of digital technology, we have a lot of acts. So we have the Digital Markets Act, the Digital Services Act, the Data Governance Act, the Data Act, the AI Act. So it's all acts. And yeah, when it was only one, if it was only a couple of them, then we could maybe think that it was a random choice of words or a random lawmaking policy. However, the choice of the word act, it could also have been regulation, because we had the GDPR, so it's a regulation. But the choice of the word act, in all these consecutive cases, all of them, most of them recently, in the last 5 years, came out, we think that amount to a specific and conscious lawmaking phenomenon. Now, when it comes to short titles in EU laws, again, it is a contested story, because normally, if we go by the book and the interstyle, the style interinstitutional style guide of the EU, they should be avoided normally. Normally what is should be the case when it comes to titling of EU law is the usual 2 or 3 lines titles of a number, all the institutions, then content, then if it amends or replaces anything, and then the formal place it has been published. So all this constitutes the title of an EU Act. However, there are cases where in parentheses we have a short way of referring to the Act. And this, okay, referring to the Act, again, this can be big, but whether we need it or not. The point is that in practice, at the end of the day, within the EU, as we know very well as legal scholars, that we nickname effectively EU law text. So we have the NIS directive. We have been working with it since 2016, but it's nowhere to be found in this text, NIS directive. The Commission itself first nicknames it, and then we come to use the nicknames. And this is also the case also today in many acts. I think the Cyber Resilience Act does not have a name, it's nicknamed anyway. So The point is that we need to be able to refer to EU law that we know among us as legal scholars. However, we have to live with nicknames and unofficial names, and otherwise not easily referenceable and referable names. This changed noticeably and notably with the GDPR that has a name in the parentheses, a short title, using the word regulation. But this has forcefully changed with all the cohort of digital technologies regulating acts. And we note that this is not a phenomenon observable, for example, in banking law or in fisheries or other fields of EU law. It's specifically when it comes to digital technologies, because we specifically have new laws regulating digital technologies, EU laws, that have short titles with the word act in it. This makes them identifiable, and this, them being regulations, most of the times, 99% of the times, the NIS2 directive being an exception to the rule, they make them directly referenceable by Europeans, which is not unimportant. And we'll come to that later when we try to bring all under a common roof. But however, the fact that Europeans are able to directly refer in a easy to use way to an EU law that regulates digital technologies, taking into account that digital technologies by now regulate all our lives, all aspects of our daily lives, and suddenly these aspects of our lives are regulated by EU law that is easily referenceable by everybody, the AI Act. Nobody needs to remember all the long title. Now it's easy to say the DMA, the DSA. So we have the regulation of digital technologies. We have regulations regulating digital technologies. And these regulations breaking the norm, breaking the normal EU style, they carry short names. And this, we thought, amounts to a specific lawmaking phenomenon, a conscious choice by the Commission, accepted by the Council and the Parliament, because otherwise it would not have come through, that digital technologies need to be regulated by easily usable names to Europeans, not to us lawyers among us, where we can use easily the numbers of the text we are working on. So this pretty much summarizes the actification phenomenon. Again, something external, something easy to observe, just reading the title of digital technologies regulating laws that were issued recently. When it comes to the GDPR mimesis phenomenon, then we have to go deeper and see how first there is a pattern, a GDPR-specific pattern, a GDPR-specific acquis, and then if it is applicable also to all the new EU laws regulating digital technologies. You may hear some hesitation in my voice because by now, since the time we first referred to GDPR mimesis, I've seen a lot of analysis, a lot of different academic journals and academic papers and chapters in books, etc., identifying a similarity between, for example, the AI Act many times and the GDPR without mentioning our GDPR mimesis, wording and just the authors. I think that by now, without me going into the methodology that we use to actually substantiate our claim that there is a GDPR mimesis phenomenon, and I think that by now, if you go over the bibliography, specifically of the AI Act, but also of the DMA, and to a lesser extent the DSA, that is true, you will see that a lot of authors have somehow implicitly or inherently, or even by reading the text, identified similarities with the GDPR approach. We did that in a more systematic, other than giving it a name, so GDPR mimesis. We did it in a more systematic way. First, by identifying what is unique with the GDPR. So a closed system of definitions and principles, which is unique to the field, a monitoring authority and an EU monitoring control mechanism. So we identified what is unique about the GDPR and then saw it repeated or proved it, evidenced it, repeated in all the other documents that were actified as per part 1 of our analysis. Hence, not in all again. Again, the DSA is an exception to the rule, and a very specific one. We justified this because of the e-commerce directive that it relates to back in the day. But we think that when it comes to new texts, new approaches by the EU legislator on how to regulate digital technologies, because it is new, because it's something unprecedented, also for the EU legislator, we think that the GDPR example, the GDPR paradigm, a way of doing things, of approach to something new, because the GDPR and personal data processing in turn was an approach, a lawmaking approach to something new back in the day that was personal data processing. It lies heavily over the head of the EU legislator and has dulled their imagination, causing them most of the time to follow a GDPR pattern. And yeah, when it comes now to the EU law brutality part, and this perhaps takes a bit more explanation. But again, at the end of the day, I think that you'll see that it is becomes quite evident. Again, we are not accusing EU law of being brutal to member state laws. This is not the term should not be taken literally. But there is some violence inherent in it, specifically when compared to what is usually the norm for EU law. So, but in order to prove our point, we have to be moving a big back and forth and with the basics of EU law and how the EU started and what it is developing into. So please bear with me for a minute. First point. So 3 or 4 separate points, a point on subsidiarity, a point on proportionality, primacy, and harmonization of EU law. So when it first started out, and what is also the case in most other usual fields of EU law, is that EU law harmonizes different member state approach. That was also the case with data protection. When the directive came in 1995, it harmonized the approaches, the already existing approaches of all EU member states. All EU member states by 1995, with the exception, I think, of only Italy and Greece, had national data protection laws, some of them more than 10 years, like Germany and France. And effectively, what the EU legislator did was they produced a model back in 1995 that harmonized, that brought together all these different approaches, the British approach, of course, the French approach, the German approach, the Dutch approach, the Belgian approach, under a common roof and a common understanding. And it's under this viewpoint that a lot of sometimes inexplicable provisions of the GDPR, the successor to the directive, can be explained. But anyway, so I use this only as an example. This is the norm. This is how the internal market and EU law operates in general. It harmonizes already existing member state law. So first we have national law, and then EU law comes and regulate and brings together, creates common standards based on the pre-existing standards of member states. So, seen otherwise, EU law does not create something new normally, or most of the times. Usually does not bring in something new, something entirely unprecedented and entirely unknown to all member states. What it does, it may bring something unknown to certain member states because other member states have been applying this internally for years or for ages. That can be the case, yes. But to everybody, create something entirely new, as for example is the case with the AI Act for everybody. This is not the way that EU law works. This is the way that EU law is working with digital technologies. Again, the AI Act comes strong as an example in this regard. So that was a first point I would like to raise. Second point is the principle of subsidiarity. So we have a principle of subsidiarity that was fundamental back in the 50s when the EU came out. That was fundamental. Otherwise, many member states of the founding members of the EU would never have come together. And the principle, and the principle of subsidiarity goes even before that. It has been a Catholic Christian principle for ages. So it's not something new. It's something that was built over ages in Europe. And it goes very simple that whatever can be done locally should stay local and not be resolved centrally. So when local reaction can resolve the problem, we should not upscale. We should not go to the next level, to upper level, and then upper level, and then to the central authority. So subsidiarity empowers locality, essentially, and it's a basic principle running through all of EU law. And of course, you will see the relevant analysis in the explanatory memoranda of each and every new EU law, how that initiative corresponds with the subsidiarity. However, when it comes to digital technologies, and these online platforms and the internet and electronic globalization and you name it, it's what we live with every day. How can it be resolved locally? It cannot be resolved locally. It cannot be resolved by a municipality in a member state, by Excel or Etterbeek in Brussels, an internet problem. But it cannot even be resolved at capital level by Brussels in the Belgian state. If it is an internet problem, if it's something that refers to Facebook. So it directly goes to the center, to Brussels, talking about all of Europe. Therefore, the principle of subsidiarity is heavily hampered, is heavily burdened when it comes to the regulation of digital technologies. That was another point. Proportionality. When it comes to proportionality, again, principle of proportionality, a very fundamental principle in EU law, in many aspects of EU law. Normally, and again, it goes back to Aristotle and ancient Greece and whatever in Europe, normally there needs to be some relation between the ends and the means, some rational relationship between the ends and the means. And so this is how we do proportionality. So in practice, when it comes to lawmaking, whatever can be resolved by directive should not be resolved by regulation. But again, when it comes to the regulation of digital technologies, how can it not be a regulation? Because it's global problems, because the internet is common for everybody, for any user in Germany, in France, in Italy, in Greece, in Belgium, it's common problems, common issues, it's one platform for everybody. How can it not be a regulation, so common law to the largest extent possible for everybody, regulating and addressing this issue? It is not easy to justify directive when it comes to the regulation of digital technologies. So again, principle of proportionality faces problems when it comes to the regulation of digital technologies. And final point, when it comes to the primacy and when it comes to EU law brutality and closing into the brutality itself, it's a primacy of EU law. Now, normally, primacy of EU law means that there are two competing ends. There is EU law and there is national law. One of them has to win, so under certain circumstances, it is EU law that wins. However, when it is the regulation of digital technologies, we know very well, as already involved in the field, that most of the times, the regulations, those acts that we discussed before, as affected by the GDPR, are the first in the field. And again, the AI Act is a useful example because in that field, in the AI regulation field, for most of, I think for all EU countries, substantially, is the first law that deals with the matter. And and the same was the case in cybersecurity back in 2016, to a large extent today, and it goes into bigger depths with the wars going on around us these days on cybersecurity. I mean, so the point is that most of the times we see that, and the same is with the DMA, to a far larger extent, because again, auditioning goes to the commission, but let's not get into that. But again, we see that in large aspects of the digital technologies, there is EU law that is first in. And that touches also the role of the EU law that we discussed before, normally harmonizes, but today there is nothing to harmonize in most member states. Most member states expect first the EU legislator to regulate digital technologies, and then for them to somehow react locally. Because this also in view of the digital technology circumstances, them being central, one platform facing all the millions of Europeans and run centrally, it is normal that a central solution will come first and then it will be localized. Therefore, when it comes to EU law primacy, there are no two competing sides. There is only one side. And all these points, separate points that I discussed for the last 2 or 3 minutes, build up the EU law brutality phenomenon, which effectively means that new laws, when regulating digital technology, the EU produces new laws that are not the result of harmonization, but are entirely new. And being entirely new, they do not go through the procedure of harmonizing. You know, the lawmaking procedure in the EU usually is all member states coming in after a first draft by the Commission and saying each one, this is compatible to my internal law, this is not compatible, we should do something with this provision, somehow to bring everything together and produce a workable model. But when there is nothing in internal law, then discussion is only on the substantial part of the proposal of the Commission, how to make it workable. And then that is transposed as such into internal member state law without, in this case, the necessary process of filtering, without, in this case, the necessary process of adaptation at the lawmaking stage. Therefore, it is transplanted, transposed as is into each and every member state internal legal order. And sometimes, yeah, it can create problems. Sometimes we have new agencies created, we have new employees created, we have new budgets created, we have provisions that may be investigatory powers. Maybe you say these are minor things, but when it comes to actually making them work together, and we've seen that time and again with the data protection, it is details that matter when it comes to enforcement and monitoring. And by producing first level brand new texts in Brussels and transposing them into national legal orders that at the end of the day are not entirely harmonized. So there are bound to be differences between the Italian and the Belgian legal systems when it comes to the actual application of the thing, of the provision. This creates tensions that are invariably resolved in favor of EU law, hence EU law brutality. Hence the brutality, because it is transplanted and as is through the regulation, the actified regulation, easily referenceable by the Europeans, it is transposed into the internal legal order. So these are the three phenomena, and I'm not going to take up any more of your time. All of them, we think, are changing the EU lawmaking paradigm in digital technologies, because it is a unique environment, digital technology that we have. The globalization we are dealing with when it comes to digital technologies is not a similar globalization that other sectors of the economy within the internal market or other sectors overall are faced with. Digital technologies, we all know, are uniquely centralized and uniquely referenceable to a single point. Therefore, I think it is unique. The paradigm, and it is perhaps normal and to be expected that the lawmaking paradigm has shifted towards the center, therefore towards the EU rather than national capitals. The point being that the model, the cooperative federalism model that has been and is still the main lawmaking model applicable in the EU today. So each national capital and each member state working together from a bottom-up approach is being transformed when it comes to digital technologies to a top-down approach with rules coming from Brussels rather than capitals and local. So this can be something new. This can be something unique. We cannot tell. For the moment, we just identify the three phenomena separate and try to bring them under a common explanation, which is exactly that. The digital technologies necessitate new tools and new responses, regulatory responses that unavoidably are such, centralized, and unavoidably present a certain level of brutality, and unavoidably bring tension to traditional principles of EU law that have been devised in the analog world, never have they imagined in the 50s that there would be anything digital in their lives. So yeah, maybe it is something unique that we'll have to deal with as people within our close circle of digital technology scholars will have to deal with, or it will be the new order of things to come, how the new EU model, EU law, and the new EU integration will apply. So thank you. I'm going to shut up. I think I've taken enough of your time. And Inge, if you allow me, I'll take your role and pass the floor immediately to Paul if he wants to correct me or in any way
Sure.
add something. Yeah. Before the questions, I mean.
Yeah. Thank you, Vangelis. It was a pleasure to listen to the way you present these things. And I have to say, for me, this book is the outcome of a lot of teaching. So if you teach European data protection law, for instance, one of the first chapters will be explaining institutional backgrounds. And if you think about it, a lot of the case law on data protection from the Court of Justice is not about data protection or the fundamental rights dimension, but it's about the institutional dimension. We had it again with the recent judgment on fingerprinting. The fingerprinting in passports regulation was squashed, not because the European judges believed that it was disproportional to have more biometrics in the passport than ever before, but it was squashed because the EU didn't choose the right legal ground to establish that regulation. So there we are. We're academics. We're apasionados of privacy and data protection, and we teach full courses on EU law, which is strange. And then try to bridge with Americans or non-European scholars, explaining there are two Europes, a supranational one and a more integrated one. And then you try to explain that federalism in the context of the EU means the opposite of federalism. So if you use federalism in the EU context, you are a proponent of a more unitarian Europe. Whereas if you use federalism in the truth, in the original authentic meaning, it means a very balanced endeavor between a central level and state levels, with that resembles in nothing the idea of a unitarian Europe, where, at least in the digital, we're seemingly going to. So I think the book does two things. It helps us understanding why data protection professors have to teach on EU institutions. Well, that has very little added value, because the proportionality testing, subsidiarity testing, and the primacy have been probably good benchmarks in the digital, but lost their benchmarking meaning in the current era. And on the other hand, it explains why in an era where a stronger Europe is heavily opposed by many, many political fractions, we see an consensus-based tendency to put all the digital in the basket of Europe, contrary to the spirit of the Lisbon Treaty and the idea of a Europe as a shared competence idea, even that idea. So I think for us, this is a book of making sense of the EU as an institution, and making sense of the certain mechanisms of lawmaking that seemingly belong to the EU, without going into much substantive discussion about data protection or regulating the digital. Yeah? So it is a professor's book.
Thank you very much, Paul. What you just said brings to my mind what Vivian Schmidt said in a couple of her books about EU policymaking being very technocratic and depoliticized. These three phenomena that you've been focusing on, and what you refer as paradigm shift, is this perhaps like paradigm shift in general in the legislative policymaking in the EU, that it's becoming more and more politicized now, perhaps to increase the relevance of the EU, or to make sure the policies resonate with the EU citizen?
Vagelis, please go.
Yeah, okay. Yes, it could be. It could be there. It could be. Of course, now we're in the middle of elections, and nobody knows where the pendulum will swing in a few months from now, when we'll have a new commission and a new parliament, because the institutions are important and their composition is extremely important. And all these phenomena actually actualized during the last 5 years, mostly, when it came to the regulation of digital technologies. That constituted the priority of the outgoing commission. So nobody knows if the paradigm shift will continue. It is a political thing. I would like to, if it comes to that, I would like to see it continue.
Okay, thank you very much. And the floor is open to questions now. Please use the raise your hand function of the MS Teams to ask questions. And please feel free to switch on your cameras. I'm not able to do so due to a technical issue, but it would be nice to see some faces if possible. Yes, yes, Tommaso. Tommaso, can you unmute yourself, please?
I can. Hi everyone. Hi Paul. Hi Vagelis. It's nice to see you again. I have a question. So I'm struggling a bit with the idea of the mimesis, in the sense that if you're mimicking something which might be flawed, and then you basically build upon this foundational this foundational structure as, let's call it I don't know, privacy as control to some extent, like this idea of privacy as control, which has been debunked by many scholars. Kaminsky was here the other day, Veldman was here the other day. I think also Paul has some criticism about this idea of data protection as being just a means of control, to the extent that we cannot really control data. And you have this mimesis which is basically still building upon this idea that we can, to some extent, control data. How does that turn this? I feel like this is a gigantic house of cards, basically, which is going to fall at some point, because we were stretching it to the extent which is no longer manageable. So to what extent does this mimesis holds all the things together if the foundations were to some extent flawed? Also, like, for the FIP principles, 1970s, do you have any idea on this, or was I totally unclear in what I'm saying?
Paul, yeah.
I think the mimesis one is a very subtle one, and the message there in the book is subtle and it's wise, and it's mainly Vagelis who saw it. But I was attending the Leeds talk of last Tuesday with Kadinsky, and I think she only confirmed what we saw, that there are blueprints being used, Kaminsky, and that the blueprints matter, or that they suggest something. And that the blueprint used for the AI Act was a blueprint going back to the medical device regulation based, and it was like risk regulation of today. But then at the end, they added some prohibitions and cloning the original blueprint or mixing it up with a GDPR-like look. And I think that's the, I think with the mimesis, perspective, we try to suggest in research a more fundamental starting point for analysis than a more detailed one. What is in it, as opposed to where does it come from? Yeah, and the suggestion is that form matters, and that the lawmaker is in a sense perverting now, because we get a copy paste of a form, but it doesn't echo the substantive power or the intent of a substantive powerful norm setting that is present in the GDPR. So it is a more complicated message, and it can be challenged. But I do think that trying to understand the formats of the message, the form, together with processes like path dependency, can bring us a lot further in drawing a general picture of all these ambitious legislative interventions. So it is possible to use a format and to embellish it or to amend it in such a way that it really does something new. But what we see is that the GDPR format has been used to do something less powerful, something less. And so we have to make sense of all these plays with form. And it might be a good, equally with the AI Act. The question is now, can we make sense of it? The second question will be, after assessment, has it flaws and can we amend it? But a next step in the interrogation should be, shouldn't we start the regulatory exercise all over, with abandoning the risk regulations approach, because the starting points for regulation are now used in a perverted way. So we get the message that Europe should be careful and respecting subsidiarity and proportionality is not used to put a brake on EU interventionism. It is used by the EU itself to propose certain regulatory models that are, from a fundamental rights perspective, not the most, not necessarily the best ones. So, and that will be the discussion of today. That is to understand how original benchmarks have lost their function, but the gates are completely open. But the original benchmarks are now used to propose market-friendly solutions for controversial issues that might necessitate more far-going substantive issues. So form matters. That is the point of that second development. This doesn't answer your question, Tommaso, but it's.
It does, because I was also thinking about the problem of the using risk regulations to protect fundamental rights, which to me is again another big problem. So you have one problem with form, exactly as you said, and one problem to me that it's of substance, that it's imagining it's easy to manage data through control. Then it's also another faulty premise to me. So there's two already faulty premises, one on the substance, one on the form. So good luck with that. Thank you very much.
Thank you. Vagelis, would you also like to answer that, or perhaps we can take new questions if there are?
Yeah, no, take new questions, because I wanted exactly what Paul and then Tommaso said on the risk-based approach and how form affects it, but it's been covered. So yeah, let's move on. Yeah.
Okay, great. So you can raise your hand, or you can just, if you want, you can also write your questions on the chat pad, and I can read them for you if you're not able to just turn on your audio or video at this moment. Yes. Can you hear me? You can hear me, right?
Yeah, we can hear you.
Okay, great. Yes, there is a question from Pablo. Yes, please, Pablo.
Can you see me? Yes. Hi.
Yes.
Thank you, Paul. Thank you, Magalis, for your presentation. It was really interesting. Well, I didn't have yet the opportunity to read your book. I just read this document, this blog post, the pieces that serve as a basis for this work. And for me, it's very interesting this concept of brutalism. And in one of your blog posts, you mentioned that this idea of EU law brutality is inevitable, and you mentioned that this kind of characteristic feature of the EU law shall decline soon. And you mentioned that in some way member states start being a little bit used to this kind of feature of EU law. But I'm wondering if you think that we are going to see in the next years, some kind of reaction from member states when dealing with this kind of with the EU law, dealing with new issues, because I think that probably we're going to start seeing new topics, new areas in which EU law will try to regulate. And I don't know. I remember, for example, regarding in the case of GDPR and standard clauses, in common law, they have this doctrine of the privity of the contract, in which it's not possible to guarantee some rights to tier party beneficiaries, and they need to in the UK and Ireland to start, making some amendments in order to incorporate some kind of exceptions in order to allow to these tier party beneficiaries to access to these rights, granted in the standard clauses. And do you think that probably regarding some common law member states, we still were going to see some issues when dealing with this expansion of the EU law, because there is this kind of core civil law, continental law perspective with dealing with EU law, or you think that probably because because of the Brexit probably, and because in some way probably Ireland and Malta are a little bit isolated, in some way when approaching this new development. We are going to see these states just again. It's like being used to this kind of EU law brutality feature.
I can go first if you want. Yeah, okay. Yeah, no, thanks. I was hoping for a question like that, because I'm going to reply to another question, to the question that you posed. But I'm going to use this as a, as an excuse to refer to. Okay, it can be political, but I'm going to refer to cybersecurity now, and I'm going to refer to security and to what's being discussed these days in order to address your first question, because I will not get into the common law, civil law thing. I think it's too technical. I'll try to see the broader picture when it comes to lawmaking and policy, and I'm going to use the cybersecurity example and what is being discussed today. But again, it's political. It depends on what the elections come out. But please consider the following. When it comes to cybersecurity, we have laws regulating cybersecurity from the EU, although everybody in this forum, in this chat, knows that the EU cannot regulate when it comes to security. But still, there is EU law brutality, and cybersecurity is one among the fields discussed in our book, where EU law has been accepted by member states, increasingly so, because we had the NIS directive, but now we have, and the Cybersecurity Act, but now we have the resilience, we have the solidarity, we have new things coming every day. So we see member states accepting the brutality paradigm, accepting that the EU will take first step, although in the treaties, there is no such competence. strictly speaking. So notwithstanding the civil common law, something missing here or there, we see the larger picture of member states accepting EU law competence for the moment in the cybersecurity field. And these days, but again, it will depend on how the elections come out, we hear a lot, maybe you have read it also on the press, about the Common Defense Pact, commonalities in defense, common drone umbrellas covering all of Europe, in view, of course, of ongoing wars around us. So, and again, we see that and of course, there is talk about a commissioner on defense, which in principle, it's inconceivable because the treaties do not allow for such a thing. But still, it's been discussed by all prime ministers, all EU prime ministers, been discussed centrally that, yeah, this is the way that we need to go forward, and this is what we'll do. And again, it will depend on who comes first in the Euro elections on Sunday. But the point is that, again, coming back to your question, I see brutality politically where we stand right now being expanded and accepted and settled, sometimes in spite of legal provisions, and sometimes bending legal provisions the way we have bent them with data protection and cybersecurity in the past, and the internal and Article 114, et cetera, and internal market. So I see this paradigm being not isolated, but expanded, to be honest, in view of the challenges, political and financial sometimes, but mainly political, that the EU is faced with. But of course, it will depend on how things turn out after Sunday.
Pablo, thank you for your question. I think I would really invite some of you to read the book in view of this question. Are they so subtle that there are no take-homes? Are they avoiding any any position taking, or what is this for a book? Because it's a very subtle book, and it's layered with a lot of understanding towards the EU for what it does. But and it's also loaded with some normative assumptions about disruption and normative stabilization and return to the normal. And all that is open for debate. And we hope the debate will pick up on some of the things in the book. You might, the examples of the music industry and the other industries that have been disrupted and then go through a cycle, and there's a return to a certain normal that isn't normal. And it has been written with a very good-willing pen. So the message is, you lose your property on music, but you get massive access to music in return. That doesn't heal the wounds of the record collector. We are the immediate access to lots of music does not replace having a big music collection of your own. But it's a way of, but nevertheless, that is the tone of the book. It is exploring these developments without taking unnecessary strong positions on all points. And even with regard to, and I'm glad we inserted the brutality nevertheless, because without that term, this would be perceived as a very friendly descriptive book. But we do take position. There is a position in it, and the position that we're hopeful that the EU will once clean up its mess, or that there will be a kind of development towards a corpus that lawyers recognize, does not hide our criticism of a very superficial regulatory process in the past years. We are simply dissatisfied with many of these instruments having been developed in silos without any attempt to integrate. So we are critical not only of how the member states should integrate all this, these bombs that are launched now as acts, but we are also very critical about the lack of effort of the EU to integrate well. And so these phrases like this act will not impede on anything in the GDPR should be prohibited. There should be a careful integration If you talk about consent in the new acts, we should understand how that relates to consent in the GDPR, if the premise is that the GDPR remains unaffected is respected. So our feeling is that this is not a position that can be maintained for long. And already now the message is to many there on the field that it is impossible to know your rights and duties with this plurality of acts that are launched. And so in one way or another, this is not a sustainable process.
Pablo, does this answer your question? Thank you. I really like to hear that our authors are more just grounded themselves more politically and looking forward to reading the book. In the meanwhile, just perhaps a question, is the LSTS library going to have the book anytime soon? Yes? Okay.
Yes, yes, absolutely. Yes. Next batch that will reach us, because it's only 1 or 2 copies that reach us for our own views. But we are ordering now, so yes, absolutely. More than 1 copies will be available, yeah, for the LSTS library.
Oh, okay, great. And yes, for the leads projects researchers, perhaps we can take 1 or 2 to our final conference, which is going to take place in Pisa. We still have time for 1, 2 questions, if there are any. And just also, perhaps I should have shared the blog posts that you mentioned. So since people didn't have a chance to read the book, perhaps they are a bit hesitant to ask questions now.
Yeah.
Yes. Yes, Paul.
Yeah, just to invite, I would indeed invite people to read it. It is written for students also. It is, why do we have a protocol on proportionality and subsidiarity, but why do we get all these acts, and why are there no more directives but only regulations coming, and what's happening? So, and why there will be upcoming elections with a far right, with a strong anti-Europe positioning, and in the digital landscape there is not one connection to that debate. Where is the European critical movement in this digital agenda? And it's good to see how the real politics work. For me, that's important. I want to understand these agendas. And so what we learn is that, as opposed to US federalism, the federalism of Europe is political, not legal. There is not enough, whereas the Supreme Court has been critical in drawing the line between the federal and the state level in the US. We don't see that in Europe. We see a pro-Europe agenda of the Court of Justice, and the doctrine of the primacy is created by this court, but it is and we see in the digital where this brings us. The court will not block this expansion of EU powers in the digital, and the member states, whenever they want, they let go all their principal objections and their concerns for state sovereignty. It could be practical wisdom, but as lawyers, you want to understand whether that practical wisdom can also be translated in principles, mechanisms that are foreseeable. And for this was not foreseeable for me, at least. And it shows us how European federalism might be way more integrative than the American one. And yes, I do believe that the connection with technocracy is is important. I'm myself reading more and more on the technocratic background of the EU and how the member states' democracy serve as a reassurance that the popular sovereignty is still there, and that we have outsourced the technocratic ingredient of our tradition that is as old as our modern liberal state. Technocracy started in the 1800s, and has been one of those more hidden elements of our functioning of our institutions, but it has always been there. Now we have cleaned it up. We can draw wonderful pictures to citizens about national democracies and the power of politics, and the technocracy is out there and as powerful as ever. And the invitation by political scholars is not to oppose technocracy, because we have not been successful in opposing it, and it will always be there apparently, but it's to make sense of it and to understand or to improve the relationship between both. So that doesn't mean accepting technocracy, but realizing that it is at work, that it is wanted by many political parties, and trying to bring that in the legal and political teaching, because our students are unprepared. They get a Gelsonian image of law with a lawmaker and a transparent procedure, but they learn nothing about hidden agendas. And the more I listen about, the more seminars I attend about the AI Act, the more I understand that even with the transparency of Lisbon, the tricks of certain lobby group, but also technocracies to influence the drafting of that act are unpredictable and merits, again, scholarly attention. So yesterday, like the whole thing on facial recognition and us wanting a ban on it, and in the last moments of the drafting, that all disappeared. So that has nothing to do with the council versus the parliament. It has to do with rapporteurs giving in on certain fundamental things at the bitter end under unforeseen time pressure. So the EU Act also needs to be studied by political scientists based on qualitative interviews with those present, in terms of how do we manage all the time behind the veil of democracy to realize a technocratic agenda. And the book is rather nice about it. And at the end, we come back to the theme of technocratic governance within Europe without judging it harshly.
Yes, thank you very much, Paul. Also, sounds to me like the reason that technocracy is perhaps like falling out of fashion is also because the politicization which is happening is also bottom up. People are really, and the civil society communities, they really just voice are very quite vocal about problems of these digital technologies. Vagelis, do you have perhaps some last remarks? In general,
No, I'm fine. I think Paul summarized it beautifully, and no, this is exactly what
yes,
the silver lining of the book. No, I'm fine with it.
yes.
Yeah. Just a recommendation: enforcement will be a key issue now in the upcoming years. It will be a key theme at CPDP, and I think at the end of the book we apply our understanding of the three developments to this choice of enforcement strategy in the GDPR, which is cooperative federalism. But if you look at all the acts, there are many other options, and the centralized pro-Europe option is having one enforcer rather than decentralized national enforcers. For instance, that made it in the AI Act, and all these things are not innocent. So whatever act you're dealing with, there is a way of connecting with the book, I would say. And of course, if you go for central enforcement, you go for more Europe. And in an era where more Europe is very criticized, that it is amazing to see how many centralizing enforcement choices are made in all these acts. That is amazing. In the other areas like criminal law with the European Public Prosecutor, all attempts to create a centralized European prosecutor were blocked by the critical European movement in the parliament, and the result is a kind of national member state controlled office that is called the European Public Prosecutor, but it is a mostly decentralized enforcement mechanism. So, and in the upcoming years also, especially when the European Commission will be the enforcer, let's all look attentively at what happens. It looks like a very strong enforcement option, but precisely what happened with the AI Act drafting has convinced me that although Lisbon has constitutionalized a lot of the regulatory processes and made it more transparent, and we write that in the book, we think that lawmaking at the European level is superior to lawmaking at member state level, inclusive in terms of inclusion and so on. But the counterpowers, and I would call that the technocratic powers, find their ways to influence. Transparency, nevertheless. So my recommendation would be to, when you, especially with the theme of enforcement, it might be interesting to understand certain enforcement options in the light of this benevolence towards Europe that is amazing in the light of the more general anti-Europe debate of today.
Thank you very much, Paul. Thank you very much, Vagelis. I'm really looking forward to reading this book. It sounds intellectually enticing and very informative. And thanks a lot, everyone, for joining us. In case you're interested with the blog posts that Vagelis was mentioning, you can contact me, and I can just be the middle person to share the material with you. Thanks a lot.
Yes.
Thanks, Inge.
Bye.
Thanks. Have a good day.
Thank you. Ciao.